Hello, welcome to Property Hotline. I'm Faye D'Souza standing in for Kavitha Krishnan, who's traveling today, but that doesn't mean our phone lines are not open for you. If you have any questions about legal problems of buying property, selling property, inheriting property, well, you've come to the right place. We have a guest here who'll answer all of your problems, and our contact details are on your screen. Soura Ghosh is in the studio, associate partner of Hariani Co. Soura, thank you so much for joining us. We have a lot of questions for you, and it tends to be, a complicated process, the legal issues when it comes to, investing in property. So I'm going to start straight off because I know our phone lines have already started ringing. Tejuman has written in, and that's an email that we received. Tejuman writes saying that there's a home in Mumbai owned by his late sister and brother. They co-owned it. Now, both of them have passed away and there's no will. Now, his sister's children, who currently live overseas, want the property, but there's no will, and his other brother is occupying that property and paying all of the, the tax and the maintenance and things like that. He wants to know who is the rightful owner of this property. It would technically be the legal heirs, wouldn't it?
Now, as regards the 50% shares of her sister's children will be entitled to that 50% shares, because her children will be the legal heirs of class 1.
Right.
As regards the other 50% of which belong to the brother,
right,
his brother's the class 1 legal heirs will be entitled to that. So the brother who is now residing in the flat,
right,
he will not be entitled.
Unfortunately, has no entitlement at all.
No entitlement.
So tell me, what is a class 1 heir when you say class 1 heir?
Now, under the Succession Act, there are division which has been made. There are class 1 heirs, class 2 heirs, and class 3 heirs. Now, you will have to go through the Indian Succession Act to understand who will fall under the class 1 heirs. I can give you an example. The son or a daughter will fall under class 1 heirs. And under the class 2 heirs, the brother and sister will fall.
So, if there's no son, daughter, or spouse to inherit, then it goes to class 2.
Yes.
And then it goes to class 3.
Yes.
Is that how
if
it
there
works?
is a class 1 heir, then they will be entitled to the property to the exclusion of class 2 heirs.
All right. So this is how it works. Anyone who's passed away who owns property, if there's no will, then class 1, like Soura was telling us, class 1 is immediate family. So that's the spouse, so husband or the wife, and children. And if there are no class 1 heirs at all, then it goes into class 2. Now, if there is a will, does the class 1 heir still have a stake or an entitlement?
No, if there is a will and the will is probated, then it will be devolved as per the will.
Okay, as per the will. Hari Prasad has also sent in a question on Twitter to us. He says he's interested in buying a flat in Bangalore. He wants to know what documents he should check before buying property. That's an excellent question, because you might be buying property from a developer, in which case there are a certain set of documents you should be looking at. And if you're buying what we call a resale flat or a second sale flat, where you're buying from another individual, where the list of documents goes up tremendously. So let's take it one by one. If I'm buying only from the developer, and there used to be a time, and I'll be honest about this, when if a bank gave a pre-clearance to a building, you could assume that the bank's legal department has done a fairly thorough check. I no longer want to take that as a given, because we've seen several problems arise even after banks have done their due diligence. So if buying from a builder, what paperwork should the developer have in hand for that building?
He has to do a complete due diligence of the property, like he has to see whether the plans have been approved by the relevant authorities, whether the CC has been granted, if it's an ongoing project, whether the CC of the flat in which he is purchasing the flat, whether CC of that flat has been granted or not. For example, if he is buying a flat on the 10th floor of a building, he has to see whether the CC up to 10th floor has been granted or not. And he has to do all the due diligence, financial due diligence of the developer. He has to do due diligence as to whether the property has been secured with any bankers or financial institutions.
But how does one find out if the property has been secured by financial institutions, or if the developer has mortgaged any of the assets?
Generally, if the developer is a company, then the secured creditor will charge that mortgage, and that will be available with the register of companies. So you will have to take due diligence of that.
We've heard that in the case of Unitech, for example, most of the assets have been mortgaged, including any future payments that will arise from buyers and from average home buyers. So how do we tell what is the financial ability of the company to finish the project when we're buying something that's under construction?
No, that's why you will have to take financial due diligence also. You will have to see the profits of the company for the last 2 or 3 years, how much profits the company has generated. All those things you need to see before taking a decision to buy the flat.
Unfortunately, that's easier said than done, because profits are only declared by listed companies, and that's a minute part of the entire real estate industry. Most of them are not listed, which means we won't have access to their profits and their loss statements. JD Sachdev, I'm told, has dialed in from Mumbai with a question. Mr. Sachdev, how can I help you? What's your question?
I have a question in parts.
Okay,
One,
go ahead.
I want to first ask the financial part of the question.
All right. Go ahead.
I have booked a flat in Bombay in Upper Jew, Andheri. I sold my old flat, and within a month I invested in the new flat. I made upfront payment of the thing, and I got a allotment letter. I did not get the agreement, and till today the builder developer has not given me an agreement. This deal took place in 2012 June 2012. After which my books went in IT scrutiny, and they refused to accept my deal, and they slapped me a notice for capital gain, saying that without agreement this deal is null and void. It is not an investment. You have sold your property, and you will be charged as capital gains. I went into for a stay order I went into an appeal on the notice, and I told them to tell the builder. The builder, they sent 2 notices to the builder, upon which he signed a MOU with me in 2015, August 4th, and expressed his inability to give an agreement to me because of various pending permissions. His building has stalled since last 2.5 years, and he's not giving me the property, he's not giving me the rent, and he's not paying attention to the income tax notices. The income tax, on the other hand, wants to charge me. They have approved my stay, but they want me to pay 15% till the hearing comes up. Till a few weeks ago, there was a headline in Times of India that tax relief will be given to those people who have booked, and letter of allotment will be treated as agreement. But the IT authority says that they have appealed against that. Where do I stand? Do I have to pay the money, and how do I recover my property from my builder?
Mr. Sachdev, I'm terribly sorry for the experience you're having right now with the real estate industry. Could you tell us the name of the developer in question?
Yes. It's a group called Kamla Landmark Group. Sai Kamla Landmark is the name where I have booked the property, and the owner is Mr. Jitendra Jain.
All right. This particular group has had several problems. We've been contacted by other buyers as well. Let's take this piece by piece. If we just look at the income tax portion, the fact that we've normally warned all of our viewers that it doesn't even matter if you've parted with 1,000 rupees or 10,000 rupees as a token payment, or any more than that. You must make sure that the developer is willing to sign an agreement, that you register immediately as quickly as you start to put down your first payment. So Soura, if he doesn't have an agreement at this point, which is the mistake here, what can he do to make sure that the developer at least gives him an agreement or gives him some sort of acknowledgement other than an allotment letter?
Sorry, before answering this question, I have our firm has earlier represented Kamla Landmark, so it might not be appropriate for me to answer this. But generally speaking, when you are paying the amount, you should understand that it's the developer's responsibility to register the agreement. So for all the purchasers who are watching this program, I would like to say, if you are paying more than 20%, then you should ask for the agreement to be executed.
What is the cap there? 20%. If I put down the down payment, I should definitely ask for the agreement to be written out and registered.
Yes.
And registered.
It's a legal requirement under the law that if you're paying more than 20%, then you can ask the developer to register.
You can insist on a registered agreement. What can he do with the IT department at this point?
You can represent to the IT department, write a note, write a letter, or write a representation saying what has happened, and you can ask them to pass a adjudication order. I mean, I do not see why IT department will not consider such representation.
But he's telling us very clearly that they're not willing to consider it, that they've appealed against the usage of an allotment letter as proof of investment. This is the unfortunate part, the delays across the country. Most of the time we find senior citizens, retired people who've invested their life savings, who also have trouble, a fair amount of trouble dealing with the legal aspects that come off it, that are facing this problem. What advice would you give him? Does it make sense for him to get a good lawyer to represent himself on both counts? Because there's one side of it is what's happening with the IT department and the notice he's received, and the other side of it is what's happening with the developer.
I think the proper remedy would be for him to approach the IT department and get it sorted out. In case the IT department refuses to do it, his remedy lies in High Court. He can go file a appropriate writ petition in High Court and challenge the order of the IT department. I think that would be the proper remedy for him.
All right, so this is what you should be doing. You should get a lawyer, first of all. There's no way around that. You have to get a lawyer to represent you, get in touch with the IT department, make a representation, ask them for the time being at least, because if they're appealing against allotment letters being used as proof, till that appeal is seen through, you can still use your allotment letter as proof. So appeal to them, ask them to consider your case. If not, then approach one of the courts against the IT department. That's your first step. The second step, of course, is what's happening with the developer, and we'll personally look into that and make sure that we can get you some help on that end as well. Radha Krishnan is written in from Mulund. He's dialed in. Radha Krishna, what is your question?
Yes, madam. Thank you. Thank you, Soura Ghosh. In
Thank
2011, our society selected a developer for redevelopment of the building. And SGM has approved under 79A. His appointment letter was given and MOU signed with the developer in 2012, who has accepted the tender. In March 2014, the developer requested the managing committee of the society to sign the DA with a sister concern, LLP, and SGM was held, and the reported LLP was approved to sign the development agreement, violating 79A. Development agreement was signed in April 2014, violating 79A, as MOU and appointment letter given earlier developer was not cancelled, and the SGM held for change of developer is also violating 79A. No agenda or no required member, and LLP was a new company. The LLP who signed the development agreement in April 14 is not authorized by the deputy registrar, and the original developer has already vanished from the scene and withdrawn as developer. So now, who is the developer for our redevelopment project, as the change developer is not authorized by the deputy registrar, which is as per 79A, they must.
Okay. Soura, what advice would you give him and the society right now?
I would advise them to first terminate the earlier development agreement which was executed with the first developer, and then start the entire process all over again, and then move to the deputy registrar for issuance of a fresh 79A order. I do not see why deputy registrar would not then issue
grant that. How do they terminate the contract with the first developer?
If the development agreement is already registered, then the proper course for him would be to file a suit for cancelling the contract, because it's a registered development agreement where some interest has been created in favor of the first developer. So the proper remedy for him to file a suit in the High Court for declaring it as a void contract, and then get it nullified, and then appoint a fresh developer.
All right. And if you need any more help with that, you can get in touch with us and we'll try and help you in any way that we can. There's a question that was left on our website by E. Koshi, who wants to know if builders are allowed to sell parking spaces. He wrote us a very long email asking us, that the fact that the Maharashtra High Court, we know the Supreme Court also had made a decision saying builders are not allowed to sell parking spaces. He wants to know, is that something that applies across the country, and can he demand a refund as an individual? So obviously, developers on paper at least are not allowed to sell parking, but most of them do. What can buyers do in those cases?
No, the developers are not allowed to sell still parking or the open space parking. It has been decided by the Supreme Court as early as in 2010 that they cannot do it. and it has been followed by the Bombay High Court as well. And though the Supreme Court order refers to MOFA agreement, which applies to Maharashtra, but I do not see why it will not be applicable throughout India. So the purchaser has to ask for refund of the amount from the builders if they have already paid for it.
Sure.
And if the same is not done, they can probably file a consumer complaint.
Okay, file a consumer complaint, demand a refund, and if the refund's not given to you, you are within your rights to file a consumer complaint with Consumer Court. We have a question on email, and the writer of this email has requested anonymity. They said that they want to know if they should be paying maintenance on a building that has no OC. If the building has no occupation certificate, is it the builders or the residents' responsibility to pay maintenance? And I just want to take a moment to just realize this. Here is someone who's written in about a building that has no OC. He's too afraid to give us the developer's name, and he's too afraid to give us his own name. It just goes to show how afraid people are of the real estate industry in the country. Soura, obviously, it's the developer's responsibility to pay maintenance. This is not the case, which is why he's writing to us. What can the buyer or the homeowner do in this case?
Definitely, till the time the OC is not obtained, is the responsibility of the developer to pay all the charges. In fact, till the OC is not obtained, it is even illegal for the residents to live in that premises. So you will have to be very careful about that, and you will have to ensure that the developer pays all the charges.
All right, I want to remind all viewers of something, that while your building does not have an occupation certificate, not only is it illegal, it's also unsafe. Because what it basically means is that the government has not given that building the go-ahead and the certification to be safe for residents. So there has not been a safety check, a fire check on that entire building. And in that case, if you've still moving in without any, or you've taken possession without an OC, it means that if there were an accident or something were to go wrong, you are entirely liable for that accident and not the developer, because there's no OC in place. And you should consider that before you move in. It's illegal occupation of the building, even though you might own that home, if you don't have an OC. And it's also unsafe. We have someone who's called in right now. N. Ramchandra has dialed in from Mumbai. He has a question for us. Mr. Ramchandra?
Yeah.
Good evening.
Good
Go
evening,
ahead.
sir. Good evening, sir. My society is registered and it is in Thane. See, in general, we can find in the AGM or SGM, the members do not come. 100% attendance is not there in the every AGM in any society in Mumbai. So, in order to make the members to come, we thought, pass a resolution, add in the bylaw that penalty will be imposed on members for not attending the AGM and also not participating in the management of the society as a committee member. So, this we want to take as a bylaw and impose penalty on those members. Because the bylaw number 165, 166 gives the provision to charge penalty, and if it is two-thirds of majority people is approved by the members in the AGM, then it can be incorporated in the bylaw, subject to approval from the registrar. I would like to know whether this process, such resolution has been passed in Maharashtra in the NO society, and whether such resolution will be acceptable by the registrar. I would like to know.
Sir?
If the bylaws of the society provides for it, then there is no difficulty. You can do it.
No, see, the question really here is the society bylaws as per Maharashtra state. Do they allow for, for them to charge a penalty for not...
No, there is no statutory requirement of imposing penalty, but the bylaws of the society, if they provide for it, then you can do it. You can amend the bylaws of your society.
Right, you can amend the bylaws of your society. Rajendra Srivastav has also sent in a question on our website. Rajendra says society management was elected by the previous board of managers and they're refusing to hand over the society. What legal action can he and the rest of the residents of the building take? Soura?
Can I just have the questions again?
Yeah, so he's saying basically that there was a previous board that elected society management members. Now they are refusing to hand over, the books, and they're refusing to hand over management of the society to the new set of managers who have been elected by the current residents. So what can residents do right now?
Then you will have to go before the deputy registrar and make a complaint, and deputy registrar will pass an order on that. That's the correct remedy.
Do they
for
need
it.
legal
If the society is
representation in
already-
order to do that?
No.
They don't need legal representation.
No.
You just file a complaint with the deputy registrar
Yes.
and ask the deputy registrar to make a decision for
Yes.
you. That's what you can do. There's another email that's come in from Zubair Muhammad Salim. He says he and his family were living in a 3-story building in Nagpara in Mumbai. The building was taken in for redevelopment by the builder 4 years ago. The builder has demolished the building completely. The builder has agreed to pay rent and did so for a year, but then stopped paying rent also, and now no construction has taken place. What can he do? We've had quite a few cases like this when it came to redevelopment, where the building is demolished, no new construction work has started, and no rent is being paid because a lot of developers are just cash-strapped. Soura, what can he do? It's a terrible state of affairs.
He has to first peruse the development agreement to see what are the consequences of not delivering the flat as per the requirement. And he can specifically file a suit for specific performance in the High Court to seek a direction from the court for delivery of the flat as per the agreement. So the proper remedy would be for him to file a suit for specific performance.
Okay, so file a suit against the developer. We have a question that's come in from Soura Ghosh, who's on the phone line right now. Alok, good evening. What's your question?
Good evening, ma'am. Hi, Soura. I'm
Hi.
from Ranchi. There is a flat in which we have recently settled in. And the developer, or the builder has incorporated a clause in the agreement, that is the registration document, that right of the roof is not there.
Okay. Right of roof is not there. That's what it says word for word?
Yes, that's right. Right of the roof is not there.
Okay.
But does it mean that access to the roof is also not there? Because all the overhead tanks are in the roof, so therefore, in a logical sense, access should be granted to the roof.
Okay. Are you you're reading the contract as it's written? It says right to the roof is not there.
Yes, as per the contract, it is there. The right of the roof to the occupant of the flat is not there.
Okay. So obviously this can't mean that you don't have a right to the roof over your head. It possibly is referring to the terrace or to the rooftop where the water tanks are. Can residents be denied access to the rooftop if it's a public space? If it's commonly owned, if it's a commonly owned space?
It's part of the common amenities of the building, so it can't be refused.
Okay, so they can't be denied, even if it says so in the agreement.
Yes.
Okay, so if it's a common space, Alok, you can't be denied access to the roof. So that would be illegal, even if it says so in your agreement. Do you have any other questions for us, Alok?
Yeah, that's right. I've got another question. My wife, who is from Calcutta, actually, her father has died in state, that is without any will.
Okay.
They've initially had 4 sisters. One of the sisters has expired. Now, alive, there are 3 sisters, and the sister who expired had also 2 daughters. One of them is married.
Okay.
What is the situation if her mother also expires in state? What is the situation wherein the property was actually belonging to her father, who died in state?
Right.
How it will be distributed among the sisters?
Okay. And so one option would be for her mother to actually write out a will. Has that been done?
No, her mother has not written a will. As such, the father, when he died in state. So therefore, we presume that the mother has got equal right over the property as the sisters also.
Okay. Soura, what would you recommend? How should that property be divided? Do all 4 sisters have an equal stake to that property?
Yes, they will have equal shares, provided there are no other legal heirs.
Okay. What do you mean by no other legal heirs?
See, once a person dies intestate, then you will have to divide the property, or the property will be devolved as per the Succession Act. As I said earlier in the program, that you will have to consider whether there are class 1 legal heirs, class 2 legal heirs. If there are class 1 legal heirs, they will get the property to the complete exclusion of class 2 legal heirs. So all those things will have to be considered. I would suggest that you talk to a property lawyer and
would you recommend, now that the 4 daughters, their mother is still alive and occupying that home, would you recommend she writes out and probates a will just to clear up all confusion? if she is the owner right now of the home, or is she only 50% owner of the
See,
home?
it's for the person to decide whether she wants to write the will or not. You cannot ask her to write a will.
All right. So what you should do ideally is contact a property lawyer, and like we've been telling you, all immediate family are rightful heirs to the property. So that's all 4 sisters. And in the absence or if one of them has already passed away, then her daughter, her children become heirs. So the ideal thing to do would be to sit down with a lawyer and go over that entire family tree and figure out how you want to do this. If the property is going to be taken by one person, then each of them will have to sign away their rights to that property. So it's a complicated process, and it does make sense that you contact a lawyer. We have Triveni on the phone line right now with a question for us from Bangalore. Triveni, go ahead. What's your question?
My grandfather had acquired a land under Tenancy Act, Karnataka Land Reforms 1961 Act.
Right.
So my father was legal heir to that property.
Yes.
And there was a rule stipulated saying that he cannot sell the land within 15 years of the grant period.
Yes.
Yes. So my father, he entered into a GPA agreement with a builder on the 14th year.
Okay.
When I was a minor. Saying that he has a right to sell and all those stuff. And that value of the GPA paper is also less. Something like 50 rupees or something, not according to the property value, but the GPA is registered. So back then I was a minor. Now I am a major. And I want to know whether I have any right over the property in which my father has entered a GPA.
Well,
But he has not executed a sale deed with the developer.
Okay, so basically he entered into a joint development deal with the developer, where the developer develops that land and shares the profits with your father. Is that how it worked?
Yes, yes.
Okay, so you have 2 questions here. One, of course, is whether or not it was legal for him to enter into that joint development deal with the developer, and if you have any ability now as a major to file a suit against your father. So our first question first: if the Tenancy Act very clearly said that you stipulated that you were not able to sell in 15 years, and he entered into a joint development deal in 14 years. Is that deal legal?
No, it is not legal.
It's not legal. Okay, and what can Triveni do at this point?
He can file a suit for injunction, seeking an injunction from implementing that development agreement. That would be the proper course of remedy.
I mean, if this happened a while ago, it's very likely that all development has already happened. But it makes sense for her to meet a lawyer because she does have the ability to file an injunction here. We have run out of time on this episode of Property Hotline. If you have more questions, contact details are on your screen right now. Feel free to get in touch with us. Soura, thank you so much for spending time with us this evening and answering your questions. Stay with Magicbricks Now. We focus on your home and on your city and any questions you might have. Thanks for watching.
You can watch live TV on our website mpnow.in. Find us on Facebook at facebook.com/magicbricksnow. And don't forget to click the like button. You can also follow us on Twitter at magicbricksnow. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/magicbricksnow.